side for the Appeals Division 1 is now in session.
Thank you. Please be seated. It's a preliminary matter. For those who feel comfortable doing so, please feel free to remove your masks. We are here for oral argument in CV20-0089, Cannabis Renaissance Group versus Fennemore Craig. As I assume you're familiar, we record and live stream these proceedings, so as you speak, I would appreciate you introduce yourself and your client. According to our current protocol, you will be arguing from council table. Please feel free to do that however you'd prefer in terms of sitting or standing. We realize that makes it a little bit difficult for you to see the clock, and we do still have a maximum of 20 minutes per side, although you're not required to use it all, though you're allowed. You will have to keep track of your own time for purposes of saving time for rebuttal. We'll try to give you signposts, and do feel free to move around if you'd like to take a look at the clock at any time. Please keep in mind we have read all of the briefing. I'm going to say attempted to study all of the record. And we have discussed the case in conference this morning. So we're prepared to hear your arguments. Please feel free to proceed.
May it please the court, Your Honors. Jesse Callahan on behalf of appellants Cannabis Renaissance Group and Mohit Asnani. Your Honors, the trial court erred in entering summary judgment against my clients. First, let's dispense with the waiver argument. The trial court erroneously ruled, and the defendants offered an argument that my clients waived their claims, that my clients should have done something different before their brief discussion with the city council in order to challenge those decisions. And that's not true. There's no expert testimony from an expert in Nevada law to support this concept of waiver. Defendants did not allege in their answer or in 22 disclosure statements the concept of waiver. It is black letter Arizona law that a defense that is dispositive needs to be disclosed, that the defense of waiver itself needs to be pled in the answer. And it cannot be alleged for the first time in summary judgment, after the close of discovery and after the close of disclosure. It was legal error for the trial court to adopt defendants' waiver defense. If there was some yet unidentified action that Cannabis Renaissance should have taken before the city council, then Mr. Sheehan and Fennemore Craig Jones Vargas would have at least advised my clients of that prerequisite. But because that defense was never pled, it was never disclosed, we were deprived of that opportunity to conduct disclosure and discovery regarding the waiver. For example, if defendants had claimed Cannabis Renaissance waived its rights by not moving forward with a post-hearing procedure related to the subsequent treatment for other applicants, we could have obtained expert testimony on what that procedure was, whether it was truly available, whether it precluded Cannabis Renaissance's lawsuit against the city, and whether defendants should have advised Cannabis Renaissance of that approach. Waiting to raise that defense until summary judgment deprived us of that opportunity.
Counsel, overarching question is just why is expert witness testimony even relevant in this case?
It's relevant in this case on the issue of causation. There's damages experts as well, but on the issue of causation, which is the issue before this court, it's relevant for several reasons. One, because we're dealing with foreign law. We're dealing with a foreign procedure, and a jury.
Are you aware of case law that supports the notion that you bring in experts to determine what the law is?
What the law is? No. What the procedures are? Yes. What the likelihood of success and the outcome of a case that never got off the ground? Yes, that's the Winston v. Strong case. And that's what the expert testimony relates to. The law itself, there is competing versions of the law on this record. Really, the sole case that defendants cite is Barta in support of this waiver argument. We bring it up in our opening brief that this was not an appeal from an administrative law proceeding. This was a lawsuit against the city seeking mandamus relief. That's what it was supposed to be.
And not to cut you off, counsel, but I understand the argument on waiver, but didn't the court also provide other analysis? Didn't the court say, waiver aside, here's why I'm entering my ruling on other grounds? Didn't the court ultimately say, look, there's substantial evidence that supports, a district court in Nevada would have found substantial evidence supporting the city council's ruling? So do we need to decide this waiver issue is my question.
Well, it is important because, ironically, the whole concept of the malpractice that was committed here was that the defendants filed this as an administrative law appeal. And they argued things like exhaustion of remedies in this
Administrative law appeal? Isn't that conflating what I've never heard that term used in the briefing. It's judicial review.
Correct.
Right?
Correct, Your Honor. So there's two critical differences. This defendant was retained to challenge the actions by the city council, to file a lawsuit against the city council seeking mandamus. The defendant filed an administrative law appeal.
Understood.
You
cited the wrong statute.
And then, on summary judgment, the defendants in this case cited those same wrong statutes and offered that legal error to the trial court, which was adopted. And they say in their answering brief it's a distinction without a difference, but it's not. This goes to the heart of the distinction between appellate malpractice and trial level malpractice. There are material differences between these two procedures, and that's why defendants are anxious to dismiss the mandamus claim under the rug, say it's not trial level. This is all about an administrative law appeal. That's not a distinction without a difference. This is not appellate malpractice.
But what new, okay, I understand your argument. What new evidence would have been able to have been produced to the Nevada District Court? In other words, let's talk about that. What would the Nevada District Court had in front of it as far as making a determination whether the city council, whether there's substantial evidence supported the city council's ruling? That's really where the rubber meets the road here, isn't it?
Absolutely, Your Honor.
What type of evidence? And I understand from your briefing, you're suggesting that there could have been some kind of additional evidence, or the court could take in new evidence that was not presented to the city council. What's your authority for that?
So there is a big dispute between what would have been provided in the record between the parties. And the reason that's why this is trial level malpractice and not appellate malpractice. In appellate malpractice, let's take a look at what appellate malpractice looks like. A true example of appellate malpractice. If a plaintiff loses after trial in the superior court and files an appeal, but files it too late, we have an undisputed record. We know what it was. And this goes to the heart of Your Honor's question. That is precisely what happens with an undisputed record. Appellate level malpractice, all the facts have been presented to the jury, and this court evaluates it as a matter of law. That's precisely what was stated in Phillips v. Clancy. Appellate level malpractice commonly occurs when the original trial has ended and the attorney fails to timely file an appeal. In our case, against Mr. Sheehan and Fennemore Craig, we were filing a lawsuit against the city, a mandamus action, not after the completion of a jury trial, not after the completion.
Why not? Wasn't the jury trial, so to speak, wasn't the trial in front of the city council? That's where all the evidence was presented, council. It was presented to the city council. The city council had deliberations, issued its decisions, and then there was the opportunity to file the appeal, called a judicial review.
The evidence that would have been evaluated by this judge in Nevada, on a mandamus claim, the first lawsuit in a trial level court, included the city staff reports. These are the individuals who are tasked with evaluating the criteria in the application, whether the application is meritorious. Critical evidence cited by Mr. Sheehan in the petition he drafted is that those staff members who reviewed in detail everything recommended approval, found the applications to be in order. That is specifically what the city staff recommended.
So let me understand that. The district court would have had that. That's part of what we have here. I forget the exact page number. I know folks have given it to us out of the 2,700 plus pages. It may be 185 is what I'm vaguely remembering. But what, because you've talked about how some things have gotten conflated, isn't your argument conflating what evidence could be taken at trial court level in the Nevada District Court for an appeal from a municipal decision as opposed to a state decision. In a municipal case, isn't the district court limited to the record that was established at the city and nothing more?
Yes, and we don't have that record. That record, what we have is the transcripts, and we have the staff reports recommending approval, finding the applications to be in order. We have the city council making comments that we're not the kind of people that they want to have these licenses, but not citing any evidence to go against the staff report.
Well, whose burden was that? This is really important. Whose burden was it to provide that record in this lawsuit?
In this lawsuit, the record was destroyed by the city. Both parties went to the city.
Wait, counsel. The city's not a party here. Are you suggesting that Mr. Sheehan destroyed the record or failed to preserve the record?
Mr. Sheehan did. When he did not timely file that petition, the record was not transmitted to the trial court. And there was a big disagreement between the experts in Nevada law about what would have been in that record. For instance, my clients say, and Mr. Kennedy says, again, procedure in Nevada law, that record would have included all the other applicants. A comparison to the other applicants and whether or not we were treated differently. And that's a critical aspect here.
What did the experts say? It said that the city clerk is there a statute or a rule that says the city clerk is there a statute that's akin to applies to the clerk of the court where the city clerk has to forward that information by law?
There's not. There is in the
But then whose job is it to do it? Is it not the attorney filing the petition?
It's Mr. Sheehan.
I understood.
And Mr. Sheehan and defendants would have created
But how
a record.
does one prevail in a malpractice case if you can't prove the case within the case? I mean, assume that this is a legal malpractice case on botching the statute of limitations in a med mal case. Don't you have to gather all the evidence in the legal malpractice case? Gather it, the x-rays, the MRIs, the medical reports, everything. You have to present what would have been presented had the statute not been botched. What's the difference here? Why is it your client's job to gather all that evidence and present to the Superior Court?
Because of the admitted negligence, the undisputed negligence of the defendants here, that record never got transmitted. The defendants don't benefit from their wrong. The defendants admit that they missed a deadline and that as a result of missing that deadline, the case never got off the ground. Just like original trial level malpractice, we never got to see that record go to the judge. But we do know this. We do have strong evidence in the record as to what would have been in the record, and that includes the city staff reports. Evaluating those applications, the fact that the state recommended my clients for approval, the fact that my clients were experienced, the fact that my clients helped draft Nevada's medical marijuana laws, and we have the transcripts from the city council where they specifically state, we don't think your guys are, quote, experienced, but they don't point to any evidence to support that. And that's what's critical here. Notwithstanding all of the evidence in the record that indisputably Mr. Sheehan says he would have transmitted to the Nevada court, that evidence that says we're experienced, it remains uncontroverted.
Weren't there some things that were plainly missing from the application that were identified by the city council?
By the city council, there were two things that were identified by the city council. One, there was a question about a discrepancy between cultivation square footage. That was explained by my clients on the record in front of the city council with no further question. And that was not stated or given as any reason to deny.
Because there's no further question doesn't mean that the explanation was accepted.
Well, there's no evidence in the record that suggests that wasn't an adequate explanation
A no
either.
vote might be something in the record that would suggest it wasn't.
Well, the fact that the question was made, that same distinction about cultivation square footage was asked of other applicants, and those other applicants were awarded licenses. So that was not a basis to deny somebody their application.
It may have, the question may not have, but the answer might have been.
The answer that was provided said the building is 10,000 square feet and the amount we're actually cultivating under is less.
What about the budget?
The budget, we actually produced that in this summary judgment record. Our client testified this was the budget that was given. Mr. Sheehan agreed in his petition. He alleged the budget was provided. Mr. Kennedy, an expert in Nevada law, reviewed all of this evidence and said, this is the budget. We provided it. It was a detailed budget and it was there. And again, that only goes to one of the 3 applications. Remember, across the board, what the city council has done is, despite the approvals of its staff, it has said, we're going to deny you anyway, but they don't cite to any evidence. They point to the budget. We had the budget. Would a Nevada judge have looked at this record and said they didn't provide a budget? Of course not. Here it is.
So I have one other question, which is, there were 3 different applications. You're challenging only, the petition only challenged 3. But there were 6 total, because there were 3 types. Was it the plan to challenge all 6? Were the 3 the correct number? I'm trying to understand why only 3 of 6 denials were even sought to be reviewed.
Absolutely, Your Honor. So it's cultivation, production, and dispensing. And for each of those 3, there's 2 licenses. So that's the 6. Business licensing and planning and zoning. My client was recommended for approval on 5 of those 6, business licensing and planning and zoning, and the other one was tabled. And so unanimously across the board, from the staff that spent months reviewing these documents that City Council relies on, that the Nevada case law specifically provides is evidence, that it constitutes evidence. And I think that's what's so critical here.
But back up. On the 3 compliance, you call them business license, compliance permits, right? That's what. Did the council vote those up or down?
The council voted all of them down.
Yeah, but yet they were not challenged by Mr. Sheehan in the petition.
He was retained to challenge them. And it was
Is that alleged in your complaint? And is that part of the summary judgment proceedings? I didn't see that in here.
What is undisputed in this record is we have a stipulation from the defendants that agreed they didn't file on time, they missed the deadline. They fell below the standard of care. If the defendants are going to come back now and say, well, we actually didn't fall below the standard of care because there were certain things that we maybe did or didn't do.
I'm just trying to confirm what happened to those three compliance permits, because it just seems odd that those weren't challenged.
That's what he was retained to do. Mr. Sheehan and Fennemore Craig were retained to file suit challenging the decisions by the city council as far as it concerned the denials of their use permits and their business licenses. That was what the lawsuit was designed to do. You needed both to operate. There would be no sense.
In this malpractice action, have you raised all 6 license or permit applications?
Absolutely. That Mr. Sheehan failed to timely file suit, and as a result, we lost our ability to operate. Now remember, our clients had to provide the same information in the state of Nevada and receive the production license and receive the cultivation license. And so when we look at these things and we say, would we have been able to operate? Yeah, if Mr. Sheehan had timely filed the suit to challenge, because again, going back to your Honor's question about what's in the record, the Nevada case law is very specific, that if city staff
You have 3.5 minutes.
provides a detailed recommendation and the city council goes against it, they have to cite evidence to support it. They didn't cite any evidence to support it, and the Nevada judge would have looked at that. We were entitled to an opportunity to present that evidence at the trial level court in Nevada. We were not able to because the defendants committed malpractice. Whether or not we would have prevailed, whether or not there was evidence in the record to support that decision or not, what that record would have looked at, the very composition of that record, those are all issues of fact that we were entitled to present to a jury. Summary judgment was inappropriate in this case. I'll defer the rest for rebuttal. Thank you, Your Honors.
Counsel.
May it please the court, Patricia Rifo on behalf of Fennemore Craig, and with me Timothy Berg from Fennemore Craig. Your Honors, there is one act of negligence alleged in the complaint in this case, and that is the failure to file a petition for judicial review, not a mandamus action, a petition for judicial review 1 day late. We acknowledged that it was filed 1 day late. So the question becomes, did the plaintiffs prove that they would have won that petition for judicial review? That question is without doubt a legal question under Nevada law, and that is the applicable law that governs that issue. It is a legal question under the law of Arizona. If you look at the restatement, it says the same thing. Nevada law says the same thing. Why? Because it is a reviewing court. A petition for judicial review, by its name, tells us that it is a judicial review of a prior proceeding. In this instance, the proceeding before the city council. There is no evidence taken on a petition for judicial review. There is no right to a jury trial on a petition for judicial review. It is a legal adjudication by the court. And under Nevada law, in the McKenzie case, it very clearly says a trial court should uphold discretionary action of a municipal body to the same extent that an appellate court upholds the discretionary action of a trial court. That is the purpose of a petition for judicial review. So once you decide, as the law compels, that this was a legal question, then it was entirely appropriate for the court, the Superior Court, to resolve it itself. Juries don't decide whether an underlying record does or doesn't contain substantial evidence, or was arbitrary or capricious, or in that vein. This is a legal question, and the court below went through an extremely careful analysis in two opinions of what the law is, what Nevada law required, what he was and was not allowed to look at and consider. So once you decide, I'm sorry?
I'm over here, sorry. We're all spread across the front of the courtroom. It's hard to figure out who's talking. With regard to what the judge could consider, then my understanding is, in Nevada court, it could only have been the record before the city council and no extraneous evidence. Is that accurate?
That is, Your Honor.
And then with that, what about the fact that they allege that the record is missing and it's your client's fault that the record isn't complete as far as what city council had?
That appears nowhere in any of the proceedings before today. It was never alleged in the complaint. It was never brought up in the summary judgment proceedings. That is a new argument that they have created for purposes of being here today. The point, Your Honors, is that from the time the city council denied CRG's licenses until the date that the Superior Court ruled on the motions for summary judgment was almost 5 years. They had 5 years to put the record that they wanted together. They didn't keep a copy of their own petition, apparently, to the city council, and so couldn't provide it to us. And when we asked for it, told us in an interrogatory that it was unduly burdensome and oppressive to ask them to give us a copy of the application that they filed to the city. Further, they said it would be a waste of resources for us to attempt to put that together. They didn't say, we don't have it and it's your fault. They said it would just be too hard and we don't wish to do it. Well, okay, they can live with that. They didn't submit it to the court below. They didn't submit any application by any other applicant to the court below. Neither did Mr. Kennedy, their supposed expert, who would never have been allowed to testify to the trial court in Nevada, have any of those materials. He just sort of surmised what must be in them.
Didn't he rely on the transcripts of it was a long hearing, correct? I mean, with the other applicants presenting their applications. Why isn't that transcript sufficient for us to conclude that there was disparate treatment here, that their clients were not treated the same as the other, I don't know how many there were that day, but these folks were not treated the same. What's wrong with that argument?
Well, I would submit a number of things. First of all, since we don't have the applications for anybody in this record, there isn't a basis upon which the court could conclude that this applicant was more or less qualified than this applicant because the applications aren't in the record. And that was one of the points that the court below noted. So what one would be left to do is what the trial court did in this case, which was precisely what they argue the Nevada court should have done, which was the trial court here said, all right, I'll read it, and read the transcript of all of the hearings beginning to end, and also reviewed the electronic record of all of the proceedings beginning to end, and concluded that there was nothing in the record, nothing to suggest that CRG had met their burden of proof. The standard here is quite high. Under Nevada law, the city council's actions is clothed with, I think the validity, I think is the word, presumption of validity, right? It is not to be overturned unless there is no evidence in the record from which they could have reached their
Let me push back against that a
conclusion.
little bit. You've got the planning and zone, you've got staff recommends approval, says the application is complete. In fact, under the code, as I understand it, the application has to be complete, or it shouldn't even be put on the council agenda. Planning and Zoning Commission approves it, and yet it's denied quite in a very short order. I mean, it's denied. I mean, honestly, I mean, I've read that portion of the transcript. It was very quick, with no, as opposing counsel said, with no citation, if you will, by the council, like as to anything particular that was missing. Other than you've got the square footage, you have the members of the group who are not as qualified as they should be. Maybe I'm leaving another thing out. I'm sure you'll correct me, but it seems thin. I mean, I know that it seems awfully thin. I don't know how to compare that to the other applicants, but just on this application, what's your response to that?
I will address it's thin in just a moment, Your Honor, but the legal point is thin is good enough. Thin is good enough under Nevada law. It has to have no evidence to support what the city council did. And one of the things that I think is important to recall as we listen to the argument that we heard is that the folks in this picture who were elected are the city council. The folks in this picture who were tasked by the citizens of Las Vegas to exercise discretion on their behalf are the city council, not the staff who puts together the recommendation that goes to the city council. There is no requirement under Nevada law, none, that the city council has to justify reaching a decision in its discretion that is different from the recommendation of its staff. But to your point substantively, Your Honor, about the record being thin, the first was the experience, which Your Honor noted. There was concern expressed about a number of the persons who were involved in the CRG proceeding as not having sufficient prominent business experience. There were multiple required documents and attachments that the city staff said were entirely missing from the application, particularly from personal history. With respect to the budget, there is no item in this record that is conclusively the budget. There was a conflict in the evidence before the city council about whether there were or there wasn't a budget. CRG said, we submitted it. The staff said, no, you didn't. The city council said, we find that you didn't. So in other words, the city council resolved that. And under Nevada law, when there is conflicting evidence before the city council, the reviewing court on a PJR is prohibited from substituting its judgment for the judgment of the city council. The production plans didn't address the security requirements. They were insufficient for review by the fire department. The cultivation plans didn't address a whole host of items that were required under the municipal code, and on and on. And I could go on at length, but it's all in our brief, Your Honor. There were any number of reasons that the city council was concerned about this.
And so I understand that was part of the report that they received, that these factors were brought up.
Yes,
Even though staff recommended an approval, they identified deficiencies and issues.
Yes, they did.
And ultimately, those staff your point is, those staff recommended an approval, they identified the issues, and city council was within their discretion to say, we appreciate that you'd recommend it, but we don't approve it given these deficiencies.
That's right. They reached a different judgment. And on an abuse of discretion review standard, which is what the Nevada court would have been looking at here, there's just simply no, and the court below found there was no possibility that the court in Nevada on reviewing this would have determined to reverse the action of the city council. And
Counsel, you have 8.5 minutes.
I'm sorry, I didn't hear
You have 8.5 minutes.
I am happy to respond to any additional questions the court may have.
Just briefly, if I were the judge sitting on this case in Nevada, one of the first things I want to do is I would want to learn what criteria should be applied to a conditional use permit, special use permit, special use permit or compliance permit, but I understand that really hasn't been discussed, so maybe wouldn't have been before the court. But I'm having a little bit of trouble because I don't see that the parties have really focused on that. You've got the municipal code. Municipal code refers to a land use development code. And am I wrong that the district court would want to focus on what the factors are of what the city council, how they decide these types of things? There certainly has to be a benchmark. So my question is, what is the benchmark that the district court would have been looking at to decide whether you can say the word substantial evidence, but compared to what? Compared to what standard?
So the distinction here, Your Honor, is that these were under Nevada law what are called privilege licenses that were being sought by CRG. Under Nevada law, privilege licenses are completely within the discretion of the city council. Now, of course, there was information that needed to be supplied in the application, which we don't have. We have only the city council and the city staff saying on the record that the application was incomplete and missing lots of information. So presumably, if we had the application, which CRG never put into the record, we could identify with some particularity what are the precise items that were required. Some of the precise items that were required are listed in our responsive brief because they're the things that the city on its face said they didn't provide. All of the missing documentation, the lack of experience, all of the other items that were described in the record and in the transcript below. So we know that they did not submit a complete application because the city said so. The city staff said so. And the city council followed on in agreement with concerns. And council in particular sort of poo-pooed a bit the discrepancy about the square footage of the cultivation facility. If you read the record, that was a big deal, that they could not accurately articulate in their application or to the city council what the square footage was of the facility that they were talking about here. And that is manifest in the record and is one of a number of reasons why this would not have prevailed on the PJR. Let me just say a quick word about the waiver argument, which Mr. Callahan raised at the beginning. There's never been a holding in this case that CRG waived claims. That was not the ruling of the court below. What the court below said was, in the alternative, and I think it was like the third in the decision tree, you should have raised these issues, your concern about your treatment disparate from others, to the city council, and you didn't. That's the waiver of an argument. No one has ever contended there was a waiver of a claim here, such that it would have to be disclosed in an answer, or the
Counsel,
like.
what would that have looked like? A letter to the city attorney after possible request, just a letter to the city clerk or letter to the mayor, request for reconsideration? I mean, is there any procedure you're aware of that's actually in place, or?
It could have been any of those things, Your Honor, but it's not an issue this court needs to address. It's just not, because, as I said, it's like the third decision tree that the court below went through in reaching the result. This is a question of law. Would they have prevailed on the appeal? As a matter of law, they would not have prevailed on the appeal. Whether you consider the arguments that they want to raise about how they were treated disparately or not. Alternatively, the court said, besides the fact that I don't find anything in the record at all to support their arguments that they were disparately treated. In any event, they were waived. So this court need not address it. If you just address on the merits, the fact that of record in the proceeding, there is zero evidence from which this court could conclude that applicant A and CRG were sufficiently similar that one was treated differently. They argued first there was racial animus, and then they kind of moved away from that argument and then started arguing, no, it wasn't racial animus against CRG. We got hometowned. This was an anti-Nevada bias. The trial court here on the summary judgment record addressed that as well and said there's no evidence of that claim either. So the court in the summary judgment proceeding did exactly what they say the court in Nevada on the PJR should have done, which is to look at the whole record and see if there's anything there. And they did, and for those reasons, we ask that you affirm the Superior Court's ruling. Thank you.
Thank you, counsel.
Thank you, Your Honors. In response to the question about criteria, the staff transcripts, the city council transcripts confirm the overarching requirement was experience. That's what everybody was asking about. That's what everybody was looking at. When it comes to substantial evidence, it is no rubber stamp. It is not about being thin. Substantial evidence does not exist to support a council decision if any of the following things are true in isolation, not in the aggregate. Arbitrariness in decision-making. That alone is sufficient to reverse a council decision. Disregarding a staff report without citing evidence. That alone is sufficient to reverse a council decision. Treating applicants disparately. That alone is sufficient to reverse a city council decision, among other things. The evidence of disparate treatment is so very strong, Your Honors, so strong. The applicant immediately before us, the staff notes they don't have knowledge in dispensing marijuana. They don't have the education to manage the facility. It was not demonstrated. Councilman Ross says, I think that you guys have the experience you need, and approves them. For us, we have the experience. It's in our resumes. It's in the CVs. We have a 55,000 square foot cultivation facility in Arizona. You guys don't have experience. That's not substantial evidence. That's no evidence.
Is that in the application? That experience is listed in the application?
It is in the record that we created on summary judgment here that our clients testified to.
No, I'm talking about the application before City Council.
The application before City Council.
But we don't have that application, do we?
Your Honors do have part of that application, which includes the curriculum vitae of all of the applicants, which was discussed on the record. We know that was provided to the City Council, and that goes back to this issue of fault about the record. The defendants say...
So why don't we have at least a complete copy of your client's application? Isn't that something that's critical and on your client's list of burden of proof to prevail?
My clients testified that they provided the same information to the state and the city. We produced all of that, and we did disclose all that, and all of that is in the record. And it includes the budget, and it includes the experience, the very experience that was discussed on the record. That's why we have an issue of fact, and that's why this is trial-level malpractice and not appellate malpractice. All these inferences about what was or was not in the record, those should be indulged in our client's favor under a Rule 56 standard, not in the opposing party's favor, not in the moving party's favor, where they're trying to get summary judgment. We have a dispute of fact as to what was and was not in that record. Now, what the City Council really did is they said, what the trial judge did, he said, it's okay to be arbitrary. He said in one instance, yeah, the City Council denied you even though the staff recommended approval. But in some instances where the staff said you should be approved, they denied you. That just means the City Council was arbitrary across the board. That's not acceptable, and that's not appropriate, and that's why the trial court should be reversed and the case should go to trial. Your Honors, that's all we ask for. Thank you.
Thank you for your arguments, counsel. We'll take the matter under advisement, issue a decision in due course. Court stands adjourned.